At this time, Mr. Hurley, are you ready to give your closing argument?
Yes, sir.
All right, proceed.
Good morning. When Dr. McCubbin concluded her autopsy, she said that a single impact from a pipe with or without subsequent breaking and possible whiplash-type injury cannot account for the multitude of injuries. I agree. Dr. Cook agrees. Dr. Bates agrees. But that Dr. McCubbin couldn't account for the other injuries doesn't mean there was foul play. That the state didn't seek further edification through other experts doesn't mean that there was foul play. And it doesn't mean that the accused has to prove his innocence. The judge instructed you, defendants are not required to prove their innocence. What occurred in the courtroom had something in common with what occurred in the 3-hour interview of Todd Kendhammer at the La Crosse County Sheriff's Office. Repeatedly in that interview and repeatedly in the courtroom, he was asked, well, how do you explain these other injuries? As though it was his burden to prove that he didn't kill his own wife, that he didn't kill the woman to whom he'd been married for 25 years, that he didn't kill the woman that he texted and talked to a dozen or more times a day, that he didn't kill the love of his life. This story really begins months before in the lunchroom at Crown. Barb told Todd that she wanted the windshield out of her garage. So he goes to the lunchroom. He says, does anybody know someone with a Ford F-250 that needs a windshield? Because I have one. And there in the lunchroom was Justin Hahn, Scott Torgerson, another fellow named Tollefson. And in the course of discussion, Heim tells him, you know, any monkey can change a windshield, but names come up, and one of those names was Jerry Loggins. And Jerry Loggins had a Ford F-250 at one time, we know that. It had a windshield problem. He told you that it was in 2014. He denied subsequently telling my investigator that it was actually in 2016. But in any event, it's true that he had a Ford F-250 with a windshield problem. So whoever said that at that meeting wasn't off. Might have been off about whether it was yet fixed or not, but they weren't wrong. And he does live right near Shufflebine Hill. And as he told you, he would have no idea whether somebody mentioned his name. And then we fast forward a couple of months, but because we fast forward, doesn't mean that when the couple of months goes by, everybody remembers every detail of what occurred that day in the lunchroom. And a couple of days before the accident, Barb says again, I want that out of my garage. And so on that morning of the 16th, they take off to take her to school. And on the way to school, he's looking for the place near Shufflebine Road that he recalls. Doesn't recall the name, doesn't recall exactly where it is, but he has it in his head, and he's not wrong, that somebody's name was mentioned that day that lived near Shufflebine Hill. And he intended to do what he always did. That is, he told the investigators, I didn't call. I didn't tell them I was coming. He said they leave the keys in the car. That was on the day of the occurrence when he was talking to one of the 3 officers he talked to that day. They leave the keys in the car, I pick it up. And what he's trying to tell him is what he usually does. Usually, he knows in advance who it is. They leave the keys in the car, he picks it up, he replaces the windshield, they come back and pick it up from him. If he'd found it that day, he was driving Barb's car, she would take her car to work, and he'd drive the truck back if they made the deal. You heard from Russ Hicks, who said Todd's the kind of guy who couldn't sit still. He was always doing something. He was selling something. He was flipping a house. He was repairing this or that. He was taking care of this neighbor or this relative or that relative. He knew him to even replace a windshield on the weekend of Cranfest in the past. That evening, they had a normal evening. Todd put up drywall for Michael and Jessica. Jordan comes home for the weekend. On the morning of the 16th, they wake up. They go through their usual routine. He showers first, then Barb does. While he's showering, Barb is packing things they'll need for the weekend when they take the camper up to Cranfest. She eats a breakfast of toast and honey, a breakfast that they had to evacuate at the hospital when they were intubating her. Jordan hears her blow drying her hair. Jordan hears them talking. Can't make out the words because they're muffled, but he never heard anybody raise a voice, never heard anybody upset. Nobody. Nobody who knew Barb and Todd ever saw them argue. Not in 25 years of marriage or during their entire courtship. Nobody ever heard him raise his voice to her or she to him. The state tells you no marriage is perfect. And the odds of that being true are great. But just because there might be a day when no marriage was perfect doesn't mean you're going to kill your spouse. That's just bizarre. Here they had a normal day in their relationship, no tension between them. Jordan hears nothing going on that would even clue him into that. She gets dressed for work. She puts on her Friday shirt. Todd fills her bubble mug, as he always did, with ice and well water. Todd calls Barb's mom, Joyce, to remind her that the plumber's going to come that day. Now, the state makes a big deal out of the fact that Barb didn't call her that day. And Barb was pretty regular in calling her mom. But not every day, as you heard. Todd called his mother-in-law 301 times in 6 months. That means he calls his mother-in-law 50 times a month. 50 times. I don't call my own mom 50 times a month, and I love her to death. His calling Barb that day was not unusual, especially to remind her that the plumber was coming. You saw a text message from Barb from 2 days before in which she asked him, should I start mowing the lawn on Thursday? You can finish on Friday. And what's the import of that? The import of it is that she knew he was off on Friday. She did know about the fact that he had switched to nights, and he told you, they discussed it, and that makes perfect sense because for their entire careers, they had talked to each other every day at the end of the day about what they did that day and what they were going to do. And in this case, it was a joint decision. Todd told you there was a young couple with young children, and he was going to be forced into going to nights, and it was going to make it very difficult for them to have daycare and arrange for that. And so he volunteered to do the last couple of months of the year, from September to December, at night instead of him. And then when the new year came, he could go back to days. Does the state offer you any reason why he wouldn't tell her? other than perhaps to suggest that he was planning to do something to her, which doesn't even comport with the speculation that they give you that he got enraged and did something totally out of character that day. So she mows the lawn on Thursday, and Dr. Cook told you that some of the injuries she had are the same type of injuries you'd see if someone were working around the house or doing yard work. And the state asked him, you know, do you have any evidence that she was doing yard work? And he said, no. But there's your evidence that she was. And I'm not here to tell you that some of those injuries came from mowing the lawn or doing this or that. What I'm here to tell you is if they're saying those injuries came from Todd, that he inflicted them intentionally, they better prove it. And they better prove it with evidence and not with speculation. They had a normal morning, and then they took off for work, for Barb's work. I'm going to shoot ahead here. Here you see exhibits 46 and 47. At 5:05 in the morning, the GPS pings Todd and Barb at home. At 7:44, it pings Barb on East Scotch Cooley Road. And Todd said he thought they took off about 7:45 that morning. And that looks to be correct. About a minute later or so, they are at Barb Thompson's house. The police searched their residence. And they searched all the outbuildings of the residence. And you heard all of the things they took. They searched everywhere for blood and found absolutely none. Sink stoppers, garage floors, whatever. They searched for weapons. Took no weapons. And Captain Zimmerman told you that even though they didn't get a warrant, they did a walkthrough of Barb Thompson's property. And you heard of no evidence whatsoever of anything that sounds like foul play having occurred at Barb Thompson's residence. At 7:49, about 2 minutes later, Todd and Barb are driving away from, or Todd and Barb are driving away from Barb Thompson's house. They're pinged driving west on Scotch Cooley Road, south on Highway 108, east on Asmus Road, and then north on County Highway M. (7:57:58) to 8:01:33 a.m. Todd is being pinged on Highway County M. Now, the state tells you that Barb's purse was in the back seat of the car, and they always said it was in the back seat of the car where she couldn't reach it. There wasn't any testimony by anybody that it couldn't be reached. People, one of the things the judges told you is that you can draw on your common experiences in life. And there are people who want everything in the front seat with them, and there are people who don't want stuff in the front seat with them, and there are people who put stuff in the front seat and people who put stuff in the back seat. But if I put my notebook in the back seat of my car from the driver's seat, I can reach around and get it. It's not that the purse was in the back seat of the car where she couldn't get it. The notion that it was placed in the back seat in a place where she couldn't get it bespeaks the idea that he took the purse from her. He put it there at the beginning of the ride, which is just absurd. Why would she give him her purse to place it in the car? Is it possible? Yes. Is it probable? Absolutely not. Once again, it bespeaks the notion of malice aforethought, not the rage that they say or suggest to you produces the injuries. And that's one of the difficulties with the state's case. On the one hand, they say evidence shows you that he's thinking about this in advance. And on the other hand, they say, no, the evidence shows you that this was a momentary, spur-of-the-moment event, not thought about. And that's because the evidence doesn't support any cogent theory that the prosecution is trying to get you to buy. This is the mug. It does not fit in a cup holder. And Todd tells everybody in almost every interview, we were talking along just bullshitting and sipping. And you saw his water bottle, and this was her bubble mug. So where's this going to go if you're sipping it? It's going to go in your hand on your lap. And that's why she put the purse in the back seat. They're going down Highway M, and he sees what he thinks is a bird. He said that 3 times during his interviews. I thought it was a bird. He told his son, I thought it was a swallow. And this is the line that he gives 3 times, at least, during his interviews that the state wants you to forget about. The state cherry picks his statements, all of which were made at extraordinarily emotional times. They cherry pick his statements for that which they think supports their point of view, that it rolled off a truck. And I will come back to that. He sees an object that he thinks is a bird, and at some point he realizes it's not, and he smashes the windshield in an effort to stop it. And he smashes it in a way, then you heard Mr. Mishalem tell you about this. Smashes it in a way that perfectly matches the curvature of a fist. And he has abrasions on his knuckles and here, exactly where it would fit in there. And remember what Mr. Mishalem says when this glass breaks. You get all kinds of breakage, especially little micro slivers that do damage to you, that you can't even see. And that loose glass was still there almost a year later when he went to look at the automobile in the garage at the sheriff's office. He tries to stop it and he fails, and it penetrates the windshield. And you heard the testimony of Dr. Cook and you heard the testimony of Barry Bates. What do people do? And their first instinct is to protect themselves and duck. And again, I remind you that the judge says you can draw on your common experience in life. And that's what you'd do. You jump away, you duck, you would be startled, as anyone would. But you would try to protect yourself. It's instinctive. It is part of human nature. And when you duck, you're restrained by the seatbelt, but not restrained in a way as occurs when the brakes are applied. It's there, but it doesn't lock unless the brakes are applied, or you move far too swiftly. Dr. Cook told you, and Dr. Bates told you, this is an unusual occurrence because most accidents involve some braking. Today, they involve airbags going off, which helps to protect the human body. But here, with no braking and the seatbelt being an obstruction, but not the restraint it was intended to be, she comes forward and her head is driven into the cup and into the dashboard. Here is the dashboard. And the glove box on the passenger side. And if you look, there is what appears to be drippings going down. And if you look at the exhibits more closely, you'll see that is precisely what it is. And that it has a reddish hue. Now that doesn't show up as well on the computer screen, but when you see the exhibit itself, you're not going to mistake the redness of that and the fact that it's blood. Additionally, now, you must remember what Dr. Cook told you. The scalp is vascular. A lot of vessels, veins, carrying blood through the scalp. And it bleeds. And that's precisely what occurs here and precisely what occurs in the automobile. It bleeds profusely. So we get blood on the dash. We get some spotting on the windshield and impact spotting that comes when the pipe comes through. Not a lot. Most of the blood you're going to find on the dash from where her head was driven in. And then, as the right turn is made and her body goes to the left toward the driver's side, you get blood on the console between the seats and on the paper in the console. And as her body, which is bent over because she's lost muscle control from the initial injury, as it goes over to the right-hand side, you get blood over there. And as she's forward, you get the pooling onto the floor in the passenger compartment, all of which is shown in the photographs that were taken at the crime lab and at the scene. Here, you see the luminol applied to the front passenger seat. Now, Mr. Stalkey told you he didn't think there was any blood on the seat where it ought to be and that there wasn't any blood on the back passenger rest. Not so. You see it here. You see it on the seat belt there. You see it over here. You see it on the console. You see it over in this area. That blood is entirely consistent with her bent over like this, having lost control of her body. And remember again what Dr. Cook and what Dr. Bates said. When you are unconscious, when you have lost muscle control, you are like a rag doll in the automobile. Every swerve, every turn is going to move your body because you have no control over it anymore. And you're not going to keep it erect. You're going to be forward like this. And it was the conclusion of Dr. McCubbin and Dr. Cook, and indeed Barry Bates, having reviewed the medical records, that the blow she received to her head, that initial blow, which caused brain injury, was sufficient to cause her to lose motor control. And she seized. And that's why Todd, when she seized, saw her flailing. She was losing her motor control. And she was additionally in an anoxic state because that cricoid cartilage had been broken. She was getting to an anoxic state. She was suffering from hypoxia, or beginning to at that point. He sees her flailing. He told you I had to push her back because she was coming over on my side. He goes around the corner, and the state makes much of the fact that he didn't stop, jam on the brakes, stop immediately, and go to the side of County Road M, as though he was intending to take her off to a secreted place. This is an occurrence that took seconds. Seconds. Go. Stop. That was about 2 seconds. The state expects Mr. Kendhammer to remember every single detail that occurred in those 2 seconds. You want to stretch it to 5? Go. Stop. They want him to remember every detail that occurred in those 5 seconds. There's much he doesn't remember. Because the only thing that was important to him at that time, the only thing was his wife. And he can remember his wife. He can remember his wife flailing. He can remember his wife bleeding. He can remember when his wife seemed to stop breathing. He can remember giving her CPR. He can remember not being so nice when he had to jerk her out of the car. He remembers everything with respect to his wife and almost nothing with respect to anything else. And why? Because we are talking about seconds, perhaps 5 minutes total, during which he is watching the woman he loves die in front of him. And all he remembers is her, and it is so wrong to expect him to remember what the traffic was like, whether someone came down the road, here, you see the front passenger compartment. And here, you see some glass, and you see dirt. Now, Mr. Grunke said that looks fresh to me. It isn't. He said it looked undisturbed, and he said he thought it came through the windshield with a pipe. We don't have proof of that, but, I probably agree with him that it came through the windshield with a pipe. And that's why you know that the state's theory here is wrong. Mr. Mishalem, who spent a lifetime in glass, doesn't do hardly anything else, spends a lifetime in construction and glass, lectures about it, studies it, goes to the manufacturing plants, 20 or more manufacturing plants, to learn how it's made, writes articles about it. Mr. Mishalem tells you that the first hit to the windshield was the fist, the second was the penetration, and the third was the fulcrum point when Todd Kendhammer pulled the pipe from the windshield, from standing at the side while on the incline at the berm to get it out while he was trying to help his wife. The state posits to you today, no. That's no fulcrum point, because our expert, Mr. Stalkey, who's not authorized by the state crime lab to give testimony about glass, our expert, who said there were 4 impacts but he couldn't find 8 fractures as there should have been, our expert says no, that other mark, what Mr. Michelin told you was number 3 in the fulcrum point, that was really number 2. Well, if that were number 2, if that were caused by the demonstration that Mr. Grinke gave you of trying to break the glass, that's where the dirt would be. Not on the inside of the car, it would be on the outside of the car. But the dirt came through when it penetrated the windshield. And that dirt you will see, if you pay attention, was smudged. And you can look at that when you're in the jury room. And over here, where Mr. Stalkey tried to tell you there was all this glass that wasn't at the when it got to the crime lab, that you couldn't see at the scene because of this bottle. I invite you to look at that picture. What you see here is not glass, that's the dirt. That's the dirt that came through. And that dirt, when she was pulled out, smudged along here. That is not undisturbed dirt. You look at it, you see what you think. Mr. Grinke tells you that pipe didn't come through and injure her because there's no blood on the end of the pipe. Well, what Dr. Cook told you was that wasn't an injury caused by being hit by the end of the pipe. What it was a blunt force trauma that came from a slapping motion. And that's why the ends, the sides rather, of those lacerations are uneven. Because had it been the end of the pipe, it would have been a slicing motion, and we would have seen that. All of the injuries are consistent. And Mr. Grunke said, look at the picture of that pipe at the scene. It's only wet on the end. It didn't get all wet. And he's correct. It was wet on the end at the time they took the picture. But it stayed there after they took the picture. And it continued to rain. And you heard the officer tell you it started to rain hard enough that he became concerned about getting more wet, and so he put something over it. That pipe was not dry. It was wet on the end when they took the picture, but it wasn't dry before they put the tarp over it. You heard repeatedly throughout the trial about the scratches on her neck and the speculation that maybe they were fingernail scratches. Dr. McCubbin said, well, they look consistent, but she would not say to a reasonable degree of medical certainty that that's what, in fact, they were. And Dr. McCubbin is a very smart physician. She went to a great university in Madison, Wisconsin, and she got not 1, but 2 fellowships after she finished her residency. She's a very smart physician. But she's also new. She's only practiced for 5 years since completing her education. And her practice is with dead people, not with injured people. She says, I think she estimated somewhere between maybe 50 and 80 automobile crashes has she looked or examined bodies from. And as Dr. Cook points out to you, she's done so in the post-airbag era. not in the era where glass used to spray all over people. Dr. Cook has been treating traumatized, injured people for 35 years. That's all he did for 35 years. He's done hundreds and hundreds, or treated hundreds and hundreds of victims of automobile accidents. And he did it in an era where the glass sprayed on people, and he told you what caused the scratches. Two things. He said there are pinpoint places that are caused by glass, and he told you how the other scratches occurred, how the flesh accordions, and it's one scrape, which he attributes to this, which was hit with such force against either her knee or the dashboard that this broke. And both he and Barry Bates explained to you the great force with which, as this came in and she ducked and turned her head would be pushed down and then come back up, and that would cause both the scraping. It can cause, depending on where it hit, also the contusions on the inside of her lips, and it caused the compression of her neck and what appears to be a whiplash injury that even Dr. McCubbin attested was there. Dr. Cook told you that in no occurrence like this can somebody turn to every injury that appears on the body and say, well, this one came from this, and this one came from this, and this one came from this. Dr. McCubbin couldn't. She told you that she could not say to a reasonable degree of medical certainty where any of the other injuries came from. What Dr. Cook said was one has to look at the constellation of injuries in connection with all the other evidence in the case and say to oneself, does this constellation of injuries in the world of all the other evidence make a certain sense? And to him, this made perfect sense, that all of the injuries he thought were consistent, with a pipe having come through the windshield, with an automobile that probably swerved, that went around a corner, where the woman had a Bubba cup in her lap at the time that the pipe came through the windshield. And with injuries that would be sustained not only within the automobile as she moved about because she couldn't control her muscles, but also consistent with forcefully taking her out of the automobile, getting her on the ground, moving her on the ground, once by Mr. Kendhammer, another time by Mr. Kendhammer in the EMT, subsequently by the EMTs into the vehicle, then in the vehicle to the hospital, moved again in the hospital, and even Dr. McCubbin said at least these injuries under the arms were thoroughly consistent with having been moved, having been handled in that way. Dr. Cook told you he has treated many, many victims of domestic violence. He has treated victims of that and other violence which produces defensive wounds, and there was an absence of defensive wounds on this body. The state, in its questioning of Mr. Kendhammer, both at the sheriff's office and on the witness stand, and in its questioning of other witnesses, has tried to suggest to you that the scratches on the abrasions on Mr. Kendhammer, the scratches and abrasions on his neck and his torso came from fingernails. Dr. Cook told you, without any hesitation, the marks on Mr. Kendhammer were not from fingernails. In the sheriff's office, with incredible objectivity, Investigator Leinfelder says to Mr. Kendhammer, I bet you that when the lab reports come back, your skin will be under her fingernails. No evidence of that. Dr. McCubbin clipped her fingernails, unfortunately, put all of the fingernails from the left hand together and all of the fingernails from the right hand together so that they touched. Okay? But when they get to the lab, does the state bother to say, we need to know if there's flesh under those fingernails? No. So they weren't scraped. The technician put the fingernails in a wash just to test to see what DNA was there. And what DNA was there? It was Barb and Todd's DNA, and we don't know from what side of the nail it came. And it makes perfect sense that Barb and Todd would have DNA on one another's hands. I questioned Mr. Scott, who I think is an earnest young man. I questioned him about his statistics because he kept saying that if one assumes that the DNA on the nails came from Barb, then there's so many hundreds of thousands or trillions of probabilities that the other DNA belongs to Todd. And I kept questioning him about this statistic because I wanted him to explain to you that the statistics increase the probability when the couple is married. And that only makes sense. You heard about touch DNA. I shake your hand, you're going to have my DNA, I'm going to have yours. And then I touch something else, it's going to be your DNA and my DNA may be on whatever item I touched. I pick up my children's dirty laundry, I'm going to have their DNA on me. And you take a married couple, almost everything they have is going to have one another's DNA on it. And I just wanted to point that out, that it isn't unusual for a married couple to have the spouse's DNA on one another. And this young man didn't even understand the statistics he was using. He couldn't answer the question. Even Dr. McCubbin, I'm going in the right direction. Even Dr. McCubbin opined that this mug could well have caused the injuries to Barb Kendhammer. The real question is, why did I have to ask her that for the first time on the witness stand? Why wasn't she given the information about this? They took the pipe to her, albeit you heard they never even opened the packaging on the pipe. They never took her this. They showed her a picture, which doesn't tell one how big it is. The state, and I'll talk about this in just a minute, the state compartmentalized the evidence when it talked to the technical people they had given this to for examination. At 8:02. Now, mind you, this is Google time, and we have many times in this. We have Google time. We have the time at the Wild Winds, which was a minimum of 12 hours off, and nobody calibrated it to GMT. Nobody calibrates this to GMT. So there are a lot of different times in this, and We don't know for sure that this is the exact time. What it gives us is not exactness, what it gives us is relative time. 911 is another clock that's used, and we don't know how that relates to the other two clocks. But we're all in about the same time period. 8:02 a.m., Barbara pings on Burgham Cooley Road. Todd's phone pings seconds later, actually about 2.5 seconds later. And at 8:02 to 8:04, Randy Erler turns onto that road. Now, Randy Erler, you heard, had called his partner because he was going to be late. Randy Erler also told you that his windows were down because it was a beautiful day. We know from everybody else it was not a beautiful day. It was overcast and raining. He turns onto the road. He tells you he goes by, and he doesn't see anything. He doesn't see damage to the windshield, and he doesn't see Todd. And I agree, he didn't see. That he doesn't see the windshield doesn't mean that the windshield hadn't been penetrated. He just didn't see it. And Mr. Meshlam told you the extent to which he went through to determine what angles he could view it from, where the sun was in the sky, and what it might appear to someone if they passed by. And Randy Erler sees a car in the ditch. He told you the door was open. He didn't stop. He was late for work. Tells you he just rode by it. So in the space of 1 second, shall we give him 2? He goes by and he tells you what he didn't see, which does not prove what there was. Now, it's the state's theory. If you look at this, the first 911 call is at 8:05 and 23 seconds, and that's by the 911 clock. So we're looking at about a 5-minute interval between turning onto the road and 911 being called. And it's the state's theory, at least as far as I can glean because it's never been specific about it, that somehow Mr. Kendhammer, for a reason unknown to anyone in the world, starts beating on his wife in the car, turns onto Burgham Cooley Road, puts the car in the ditch intentionally, gets out of the car, and pulls and drags and forces his conscious wife, because it's the state's theory that she had not yet received that blow that rendered her unable to control her motor function, that he pulls her out of the car and beats her, producing no defensive wounds whatsoever. And then, when he's sufficiently beaten her, goes into his trunk and takes a pipe which he thought about taking ahead of time and bashes it into the window, and being unsuccessful, bashes it through and pulls it out, somehow getting blood on particles of glass outside the windshield when she hasn't bled enough yet to do that. And he does it all in a public place before Mr. Erler passes by, right? Because the significance to them of Mr. Erler in his not having noticed the damage to the windshield is it hadn't occurred yet. So what does that give him? 2 minutes to think of all of that and do all of that. And that's absurd. This is from the second 911 call that he makes. he says, and he's screaming here, I'm sorry the audio didn't work as we planned. How long, how long? Get her off the road. Should I get her next to the road? I'm going to try to do something with her. I'm going to put the phone down. I'm sorry it didn't play. I wanted to remind you of that which you probably don't need to be reminded of, and that was his tone of voice. That was a tone of voice of a truly distressed person. Not somebody who was making this up as the state would wish you to believe. How long, how long? He says, I'm going to try to do something with her. And he does what he told you he did, because her head was facing down by the wheel of the car after they fell out together. They fall out together. He's giving her CPR. On those calls, the state is telling you he's not giving her CPR. On those calls, you can clearly hear as he is pumping, because she had stopped breathing. And so he moves her from where she was. Now, the state, during the trial and during their closing argument, and I suspect again, when they give their rebuttal argument, and I can't get up again and say anything, is going to show you that wheel rim. And that wheel rim has a couple of drops of blood on it. And if you look at the grass, there's blood on the grass. But as Dr. Cook pointed out to you, the blood on the grass is nowhere near what it is inside the car. Because that's where the injury to the part of the body with all the veins, the vascular scalp, with everything running through it, where it can spurt while the heart is pumping. That's where the majority of the blood is, not outside. And when they fell down, you heard even Mr. Stalkey tell you that he couldn't tell whether the spots on the rim were an impact spot or whether it was a castaway, as in someone falling down and blood that they had on them casting onto that. He began pumping her to save her life. I'm reminded by the state's approach to this of the parable of the blind men and the elephant. It's an old parable. Nobody's sure whether it originated in India or Burma or Thailand. But a group of blind men heard that a strange animal had been brought to town, an elephant. And none of them were aware of its shape and form. And so they thought they would all go and touch the elephant to try to see what an elephant was. And when they found it, they groped it. And the first one put his hand on the trunk. And he said, "This elephant is a big snake." And another went to its ear, and he said, this creature is like a fan. Another touched its body. Said, no, it's like a wall. And another touched its leg and said, no, it's like a pillar. The one who felt his tail thought it was a rope, and the one who felt its tusk said, no, it's really like a spear. And the parable teaches that subjective experience can be true, but it's inherently limited by its failure to account for other truths, for the whole package, for the totality of the truth. The investigation into what occurred here was an interdisciplinary problem. It involved pathology, it involves medicine, and specifically trauma medicine, it involves biomechanics, it involves glass, it involves DNA, it involves blood. and the state never approached it that way. The state approached it with tunnel vision. It was like the news media on this case. During jury selection process, we took a long time with any of you who had read anything about this case, because we had to make sure that your minds were open, that you had developed already an opinion about the case, that you would listen to the evidence objectively, because in order to reach the appropriate conclusion, one must be objective. Within minutes of police arriving at the scene, you overheard in one of the tapes of after talking to Todd Kendhammer, Officer Leffelholtz turned to the other officer and say, "Is this normal?" And people begin to question him that day when he is terribly distressed. 3 officers questioned him that day. 3 officers questioned him that day, and over 50 times during the questioning, over 50 times, all he says is, "How is she? Can I see her? Will she be okay?" 50 times or more. Because that's where his head was at. That's where his head had been for 25 years. It's where his head was at that day. The love of his life. He gave answers to questions that weren't accurate. And the state says, because when his wife is being attended to by first responders on the ground, when he knows she hadn't been breathing, when he's saying, "Is she okay? Can I go to her? She doesn't like to be alone," that his failure to be accurate meant he was lying. Right away, interpreting inaccuracy as lies rather than the product of distress. In less than 2 hours, they were at his home questioning his son Jordan. Do they argue? How are their finances? At the autopsy, no investigation completed yet. No one's gathered evidence, no one's looked at evidence. At the autopsy, the pathologist says she didn't get all these wounds from a single blow to the head from a pipe coming through the windshield. Okay, that's true. But the immediate reaction is he beat her. And that's where the investigation goes from then on. They don't go looking for anything like the truck he described. I'm missing something. Here we go. On September 22, they come back to interview him. I want you to remember something that they said to him on that day. After they get him to the sheriff's office by lying to him on false pretenses. And I recall Mr. Grunke saying that his grandfather taught him, you can't trust somebody who lies. Apparently means unless they wear a badge. They lied to get him there. And as he comes into the room, Sergeant Yaley says, we just want to talk to you because we know how emotional you were during the first statements that you made. And Investigator Leffelholtz told you he knew that this was occurring the day before the funeral. You heard from Mr. Kendhammer and family members how distraught he had been. He hadn't slept for almost 5 days. You heard him say on the interview, "I haven't taken my medication." He spent the morning away from his family, grieving by trying to make a wooden heart to be at the funeral. Sergeant Yaley's statement that we just want to talk to you because we know how emotional you were in the prior statements tells you that they know you don't get accurate statements from someone who's emotional. And yet they pick the most emotional time of his life. They know it's the day before the funeral. And they start questioning him. And they accuse him in this interview. They accuse him obliquely, they accuse him directly of lying and killing his wife. Without any evidence whatsoever. They tell him he had a financial motive. "I bet we're going to have your skin under her fingernails. She was upset with you for taking the night shift." Are you kidding me? Are you kidding me? I mean, the state said it again today in their closing argument. Does this make sense to you? That if your spouse is upset with you for taking the night shift, your answer is, "I'm going to beat them to death"? He tells him, "You weren't going camping. You don't install glass. It's a complete lie. You would have gotten in trouble if you took the day off, and you took the day off instead of taking the shift cycle. You weren't going to look for a Ford F-250, even as the police were searching his home and found the windshield, a fact which they never told you, which we had to tell you. She wasn't dressed for work," they said, accusing him, however obliquely, of having beaten her unconscious and then dressed her and put her in the car. They said she was never late for work. Not true. The day before, and the exhibit is in evidence, the day before she was a couple minutes late, you heard from her coworkers that they took flex time. You heard from the supervisor she didn't know about the flex time. This was tunnel vision at its worst, with no evidence whatsoever, none whatsoever. They bring him in at the most emotional time of his life and accuse him over and over again, just as the prosecution has done today, of lying and of killing his wife. Officer Leinfelder keeps telling Todd repeatedly that he is responsible to explain what Leinfelder didn't understand. He is responsible to account for every injury to his wife. And that's precisely what the prosecution told you today. He can't tell you how all these injuries happens. That leaves only one conclusion, that he's lying and therefore he did it. This is not an interrogation room at the La Crosse County Sheriff's Office. This is a court of law where the state has a burden to prove to you and to prove to you beyond a reasonable doubt that he killed his wife. Not with the absence of evidence and not with speculation, but with proof. Proof beyond a reasonable doubt. And toward the end of that interrogation, Sergeant Yaley says, and I quote, "It's not just me and Investigator Leinfelder hammering you in the hope we get some trophy at the end of the day." That was a lie. And when he's there, he explains why he thought it was a pipe falling off a truck. He tells them more than once, at first I thought it was a bird. And he says, it had to come off the top of the truck. It was up higher on where it came off the truck. And the questioner says, what makes you think it was coming off the, and he says, because it wasn't. It wasn't down here when I first seen it. It was up. It's not like it comes off the bottom or the side of the truck. It had to have come off the top of the truck. And what he's doing here is taking him through his thought process. However unsophisticated it was, what he's telling him is, I thought I saw a bird. Subsequently, and unfortunately, he knows what it is. It's a pipe. And so when he's first asked what happened, he doesn't say, a bird came through my windshield. He says, a pipe came through my windshield. That's true. And as he's trying to make sense of what occurred, he figures a pipe rolled off a truck. And he really can't remember the truck, because who can remember the last car that passed them on the road? Which one of you remembers the last car that passed you on the road on the way to the courthouse this morning? And you didn't have an earth-shaking experience occur to a loved one. And the police, whether intentional or not, and probably unintentional, are complicit in this, when on the very first day, when he can't really remember anything about this truck other than he thought it was an old flatbed dark, close your eyes and try to remember. And so he tries. And the more he tries to think of a color or something else, the more the state cherry picks that to say, see, you're lying, and never addresses the notion that he said he thought it was a bird. And that what he's doing is going through a thought process that may not be accurate. It may not have fallen off a car. We don't know. It could have been lying in the road to be kicked up by a passing vehicle, either oncoming or passing him. We don't know. And the state doesn't know. And what they want you to do is to fill in the blanks by speculating on guilt. The cross-examination of Mr. Kendhammer by the state never let go of the fallacies with which they had confronted him on that day in the sheriff's office. In the sheriff's office, they accused him of having financial difficulties. As they were talking to him, they get text messages, we found some unpaid bills. And so, when he's on the witness stand, the state questions him about the 2 unpaid bills that they had, as though to suggest to you that there was some financial motive for killing his wife. What the state never told you, and what we had to bring out, was that they had subpoenaed all of his financial records, from Wells Fargo Bank, from Seven Bridges Bank, from Thrivent Insurance, from First Community Credit Union, subpoenaed his credit report from TransUnion, none of which supports the conclusion that they had financial problems. You heard from his banker. His mortgage and car were paid 6 months to a year in advance. Todd thinks it's a year in advance. Never turned down for a loan. Had a $450,000 line of credit. Cross-examined about whether going to the night shift was a motive to kill his wife. Suggested to you again here. Todd explained to you He could have taken the shift cycle day off, but then if he worked the next 3 days, he wouldn't get time and a half or double time. So he chose to call in and take a 5th point, and then after he'd gone up and put the camper, he was going to come back and work on Saturday, Sunday, and Monday and get the time and a half. And his description to you of the system they have at Crown was thoroughly consistent with that of the other employee from Crown that you heard. Cross-examining him about the same allegation of her skin being under his fingernails, a fact that the state knows there is no evidence to support. The tunnel vision never stopped. 2 weeks before they put out a notice to the public. And did the notice to the public say, can anyone recall whether there was a truck of a certain description on the road that day, or whether there was a pipe of a certain description? No. What does the notice say? If you saw anything suspicious, let us know, with a picture of the Camry. They're not looking to find out whether a pipe could have gone through the windshield. They are looking to prove that he killed his wife. The state doesn't approach this as an interdisciplinary matter. Not only doesn't it talk to a physician other than a pathologist, never talks to a glass expert. Tries to pass Mr. Stalkey off as an expert on glass when he's not. The state keeps telling you that the judge has instructed you they don't have to prove motive, and that's true, they don't have to. And if I walked up to somebody and in front of 10 witnesses shot that person through the head, you wouldn't have to prove motive. But when you have no motive, and all the evidence suggests there is no motive, one has to ask, where is the proof that this was some intentional assault? What reason would Todd Kendhammer ever have to harm his wife? Because everyone they have tried to suggest not only is not supported by evidence, it makes no sense whatsoever. The judge told you, as he said, in weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. You do that. Use common sense, especially in answering the question, why would this man ever want to kill the woman who has been his entire adult life? The woman that he fell in love with when he was 16 years old. The judge also told you, this is the law. If you can reconcile the evidence upon any reasonable hypothesis that is consistent with Mr. Kendhammer's innocence, you should do so and return a verdict of not guilty. And that's what I'm asking you to do. I'm asking you to reach that conclusion by weighing evidence, by using common sense, and by demanding proof, and not taking the state's invitation to fill the blanks in with guilt. And when I'm done, the state gets to give a rebuttal argument. You can appropriately assume that if I were permitted to, I'd be jumping up and down in my seat wanting to talk to you yet again. But I don't get that opportunity, and they get it because they do bear a burden of proof beyond a reasonable doubt. And so far, throughout this entire case, the state has never told you any mechanism by which the injuries they claim that Todd Kendhammer inflicted on his wife occurred. And I don't know if they're going to do that in rebuttal. But if they do, I want you to ask yourself, why are they waiting until the defense has sat down? Why have they waited till now? Why not have told us at the very beginning of this case? And I want you to be thinking about how I would reply.
Objection, call for speculation.
Sustained.
I ask you to do your duty, and in doing that duty, to find Todd Kendhammer not guilty. Thank you for your attention throughout this trial.